Hello, everyone, and welcome. Thank you for joining us today. My name's Justine Nolan. I'm at the Australian Human Rights Institute at UNSW Sydney, and I'm going to be joined today on this webinar by Freya Dinshaw, who's the Senior Lawyer at the Human Rights Law Centre, and Amy Sinclair, who's the Regional Representative for Australia, New Zealand and the Pacific for the Business and Human Rights Resource Centre. I welcome you today from the unceded lands of the Bedegal people on which UNSW stands. And acknowledge our Indigenous leaders past and present. Today's webinar is focusing on our recent report, Broken Promises, which is a collaborative project, research project, a 2-year research project that's supported by a number of people and many funders, but including the Australian government's National Action Plan to Combat Modern Slavery. This is a research consortium that we have been working together now, really for about 2 years, and it's still ongoing. And you can see here the long list of authors for this report who contributed to this. Alongside this support also was very valuable pro bono support from the law firm Hall and Wilcox, who were assisting us with some statement assessments around that. But very much it's a consortium, and today Amy, Freya and I are presenting the views of the group and giving you the outline of our recent Broken Promises report, and we'll put a link to the report in the chat for you in case you haven't seen that yet. So the format of today is we're going to do a bit of a Q&A, show you our key findings, what's different from our year 1 and our year 2 assessment in relation to this project. And then we're going to have time for Q&A at the end. But I also encourage you as you go along, if there are particular issues you want to raise, please put questions in the Q&A Zoom function, and I'll try and build those into the presentation. This project arose out of a question looking at the disclosure framework that's set out in Australia's Modern Slavery Act, which is established in 2018, but it's been in operation since 2019, which means now that we've had 2 years of reporting from the Australian government, but also from companies operating out of Australia. So one of the questions that we're looking for is trying to see how effective this framework is. Is it driving real change? Is it assisting companies and governments in tackling modern slavery in a meaningful way? What does this form of reporting add? And so what we're trying to do with this, and we'll discuss the methodology around it, is really assess the effectiveness of Australia's Modern Slavery Act from a reporting angle. So let's start with some of our key findings in relation to this. And Freya, if you could take us to the key findings of the report. What was sort of the aim of this report? How does it differ from the earlier report, Paper Promises, and perhaps give us a snapshot of the key findings of Broken Promises.
Thanks, Justine. And before I begin, I'd also like to acknowledge that I'm on Bunurong country and that sovereignty over the land was never ceded, and I pay my respects to elders past and present and emerging. So in Paper Promises, our early report, our aim was essentially to get behind modern slavery reporting to try and understand whether companies were identifying key risks in their high-risk operations and supply chains, and whether they were taking effective action to address those risks. And so we purposely selected a group of 102 companies sourcing from sectors with known risks of modern slavery. And in particular, that was garments from China, PPE or rubber gloves from Malaysia, seafood from Thailand, and horticultural produce from here in Australia. And we also, of course, wanted to see to what extent the requirements of the Act were being met, as well as to what extent we could find evidence of good practice among the companies that we reviewed. But in Broken Promises, as Justine just flagged, our main aim was really to track performance between years 1 and 2 to determine to what extent we could see evidence of the race to the top notion that underpins the Modern Slavery Act, and whether there was evidence of continual improvement between the first 2 rounds of reporting. But what we found was that on the whole, reporting improved minimally, with the average company improving its score by just 7% between the first and second rounds. And when we track against the findings from last year's report, we find that 2 and 3 companies were still failing to address the key mandatory reporting criteria that are set out in Section 16(1) of the Act, which was down from 77% in round 1, but still is a majority of companies. Nearly 1 in 2 companies, 43%, continued to fail to disclose key modern slavery risks in their statements, down from 52% in the first round of reporting. And there's still only 33% of companies that appear to be taking any form of effective action to address their modern slavery risks, which was up from 27% in our first round. We also found that over half of the commitments that companies had set out in their first round reports remained unfulfilled when we looked at second round reporting, and that there was some evidence of companies substantially recycling or rolling over statements from the previous year. And so what these findings show is that progress on addressing modern slavery remains quite modest, and there's little evidence at the moment that the law is really driving meaningful action by companies to lift conditions for workers that are at the highest risks of exploitation. So while there remained a handful of high-performing companies that did well in the first round and continued to improve in the second round of reporting, what we're finding is that 3 years into the Act's operation, most modern slavery statements are still lacking basic information, making vague commitments that aren't fulfilled in practice, or fail to reveal evidence of effective action being taken to address modern slavery.
Thanks, Freya. So I think that takeaway in particular, the stat around 66% of companies are still failing to address even the mandatory criteria is very significant, looking at what the Act is aiming to do. So before we go on to dig down a little bit into these findings, Amy, can you tell us a little bit about how our research was conducted, what the sort of methodology was approached, and how it differed a little bit from year one?
Thanks, Justine. It's a pleasure to be joining today, and I'm joining from the unceded lands of the Camaragal people in Sydney, to whom I pay my respects. So in relation to the methodology for broken promises and this second stage of research, we followed the same methodology that we used in the paper promises research, but we did have some adjustments. So, for example, this time around, we weren't looking at COVID responses of companies. So with broken promises, we were examining the second round statements for the same cohort of companies that we reviewed for the first report, those that were available on the register. We looked at the same group of companies in both reports, and those companies are listed in the annexures to the reports. And so these are companies that are sourcing goods that have well-known risks of modern slavery, and they're operating in 4 sectors, which Freya mentioned. There's garments from China, disposable rubber gloves from Malaysia, Australian fresh produce, and seafood from Thailand. And in running the research, we had a trained team of assessors who reviewed the statements against a set of 63 indicators. Our indicators are designed to measure compliance both with the reporting requirements of the Modern Slavery Act, but also more broadly the depth of companies' responses to addressing modern slavery. Each statement was reviewed 3 times and the scores were validated by assessors. What was new this time around was that we were also assessing the extent to which the forward-looking promises that were made in first round statements appeared to have been met in the second round reports on the basis of the information that companies are disclosing in their statements. So with paper promises, which was our first report, we found that 89% of the statements that we looked at contained some form of commitment to continuous improvement, which is a very high level. So we really wanted to see what had happened with these commitments in the intervening period. Also, with broken promises, we were looking at the extent to which statements seem to have been recycled from round 1. And we treated statements as recycled where there was minimal or no changes at all to the text of the statement from round 1. And where there were, the changes were so insignificant that it had no impact on scoring. And we found that around 8% of the statements that we reviewed in round 2 show a level of recycling, which is demonstrating a lack of engagement with the law by those companies.
Thanks, Amy. And the other point that's noticed on this slide is that there were some statements that were missing. Freya, can you explain what we meant by that?
Yes, so initially, as Amy mentioned, we set out to review exactly the same 102 statements that we looked at in paper promises. However, that didn't turn out to be as easy as we initially anticipated. And after most of the statements were published on the register, we found that 10 statements from our original data set were missing. And so we undertook a bit of research, and from that we found that about 3 of those statements likely had legitimate reasons for not publishing second round statements, either because they might have fallen below the threshold, they were in a corporate restructure, or submitting a statement with another corporate group. And of course, year on year, there will be changes to exactly which reporting entities are required to put in statements. However, this still left 7 statements, which we've described as missing statements in our report. And we think it's very likely that those companies may not have put in compliance statements as required under the Act. But the difficulty for us, I guess, there's 2. Firstly, it's very concerning that if some companies aren't even putting in statements, that's a clear problem around the Modern Slavery Act's effectiveness. Because as we know, most of us watching this call understand that there are no penalties or hard consequences for companies that don't put in statements. But on a broader level, missing statements sort of send a signal that companies and the government to some extent aren't taking seriously their responsibility to combat modern slavery, given that the Modern Slavery Act is currently our primary method of tackling supply chain modern slavery issues. There's no regulator that's been appointed to monitor compliance under the Act, and there's no public list that we have to see who is required to report under the Act. There's also no public information about companies that have failed to report. So if you go to the register and try and find out information about whether a company you're supplying from has actually issued a statement, you can't find that information out. And so instead, we're kind of left with the system which relies on ad hoc market forces to monitor disclosure efforts. And this is really insufficient. It's an unsustainable mechanism to engender compliance with the law. So that was one of the challenges we found when undertaking this research.
Thanks, Freya, and thanks for your questions that are coming in, and some of them I'm leaving until we come to that section of the report. But Amy, just before we leave the method, there was a question, and perhaps you can just answer sort of really quickly around the different types of businesses that we initially selected in paper promises to give an overview of business. So we didn't just select all the top, sort of biggest businesses. Amy or Freya, do you just want to mention very little, sort of a snapshot of that process?
Yeah, sure. We looked at the same companies for both reports, but when we selected those companies initially, we really wanted to get a mix of different types of companies and different sizes of companies, so we could really sort of gauge whether size is related to strength of response. So we were looking at companies rather than other reporting entities, and we were looking at companies that were unlisted, listed, that were operating at different levels of the supply chain. So a real mix to get a good spread of data on how companies are responding to the Act.
Terrific, thanks. So one of the questions that has come in on the chat from Valerie is around how do we define effective action? And this slide will answer that question, Valerie. So what we were looking at was trying to dig down a little bit, and rather just saying, trying to give you a sense of what indicators we were using to discuss effective action. So overall, we found that just 1 in 3 or 33% of companies demonstrated effective action. And these are indicators which give you a sense of how we assess that. So if a company is undertaking and reporting some form of human rights due diligence and giving some information around that, and that we found was 26% of companies. Some companies talk about and disclose evidence of what they've done to put in place responsible purchasing practices and how they may be adjusting their business model and operations in a supply chain. That was 20% of companies discussed that. 21% of companies expressed a commitment to paying a living wage. 18% looked at processes for preventing workers being charged recruitment fees, which is an indicator of forced labor, a form of modern slavery. Only 14% of companies actually referred to or discussed or presented evidence around freedom of association for workers, which is one of those basic underpinning rights that the International Labour Organization recognised that leads to other worker rights being realised. 35% of companies disclosed evidence of some form of collaboration, working with unions, civil society groups, migrant worker groups, human rights experts, academics, etc., which is encouraging, but only a 1% increase from our first report. And finally, 19% of companies actually took the time to reflect on the effectiveness of their actions and their responses over the last year. So that, I hope, Valerie, gives you a little bit of a snapshot of what we were looking at as some of our indicators around effective action. Amy, can you tell us a little bit about this sort of what we hear about improvements and whether the Modern Slavery Act is encouraging this race to the top?
Yeah, sure. Thanks, Justine. So the aim of the Act is to create a transparency framework that will encourage companies to race to the top in terms of taking action to address modern slavery. And we wanted with this research to sort of understand and to get to the bottom of the extent to which this can be said to be happening. I should say that there's no doubt that the Act is helpful in terms of its value as a transparency measure. It's really helped raise awareness about modern slavery issues, particularly at board level. It's codified expectations for businesses. It's yielded useful information, which is allowing improvements in corporate responses to be measured over time. And it's also created a really important avenue for engagement with businesses about human rights issues that we just didn't previously have. However, our research findings indicate that reporting in and of itself isn't bringing about the transformational changes that we really need to see to effectively respond to modern slavery. We found that the average rate of improvement in the quality of statements between round 1 and 2 is only 7%. We also found that companies are still not disclosing actual cases of modern slavery that they have had to address. With broken promises, so that's the round 2 reports, only 14% of the statements that we looked at provided this information about real cases of modern slavery that they'd encountered. This is up from the 8% that we found in round 1, but the quality and the extent of disclosures on this point remains very limited. Where we have detected change between round 1 and round 2 reporting, it's generally not happening in those areas that are more fundamental to addressing modern slavery. So, for example, we're not seeing in statements evidence of widespread business support for freedom of association. We're not generally seeing the implementation of responsible purchasing practices, responsible business models. We're seeing limited evidence of effective and safe engagement with workers themselves. And we're not really detecting much in the way of satisfactory resolution of grievances. So even on the basic sort of compliance measure, looking at the Section 16 mandatory reporting requirements, we found that companies are failing to achieve adequate results, with 77% of companies that we assessed failing to hit all of the reporting areas in round 1 and 66% in round 2. So even if we are seeing improvements in reporting techniques over time, our research is finding that improvements in reporting doesn't necessarily equate with evidence of substantive compliance in companies' statements and the introduction of effective steps to address modern slavery. So the types of incremental improvements that can be achieved through this type of transparency approach, which are sort of nudged along slowly over time, are really unlikely in the absence of other measures to adequately address modern slavery over the longer term.
Thanks, Amy. Freya, obviously the report's called Broken Promises for a reason. Can you just recap on what this is, and also perhaps during this just answer a question from Vanessa on the chat, which was references your reference to recycling of statements earlier. Vanessa asked if a company repeated some foundational information about existing policies and procedures, but still noted changes in implementation, was that recycling?
Thanks, Justine. And just to answer the question first, no, we took a very conservative view of what was recycling. And in the statements that we determined to have been substantially recycled. Literally, a compare was run between round 1 and round 2. And so the criteria was really there was very minimal textual changes. And if there was a textual change, that it wasn't a qualitative change. So we would sometimes see a superficial change, perhaps the number of employees changed between years or something like that. But it was a fairly conservative approach that we took on that point. But in terms of why the report is called Broken Promises, when we were thinking about how to look at this question of continuous improvement between rounds 1 and 2, we thought it would just be interesting to explore and track through whether the companies that the commitments that companies themselves made in the first round were actually translating to actions in the second round. And as Amy mentioned, in the first round, we found that almost every company, 89%, did make some commitments to continuous improvement by setting out future plans. And typically what we'd see is that there'd be a section towards the end of the report which would set out a roadmap or a plan for next steps. And that's really good practice. And it is what we want to see, because obviously there's always room for improvement in this area. Some of the examples of the kinds of commitments that we typically see would be to increase training or awareness, reviewing contracts or supplier policies, mapping out parts of the supply chain, or joining a third-party organisation like FedEx. So what we did was we catalogued all of the commitments from the first round of statements, which equates to 532 commitments or promises in total, so about 5 to 6 commitments typically. And then we checked when we were reviewing the second round statements whether or not those were met. And what we found was that over half, 56%, were not met in second round statements, which is why we've labelled the report Broken Promises. However, when we were undertaking that analysis, we also did a bit of work to kind of look at the kind of nature of what was being committed to in the first round. And what we found was that approximately a third of the commitments that were made in first round reports were so vague or general as to be either self-fulfilling or essentially meaningless. And some examples of this are to further engage with suppliers or to continue to raise awareness, commitments that you could make out no matter what. And so interestingly, when we excluded those commitments, we found that it was more likely only 2 and 3 commitments, only 1 in 3 commitments was actually fulfilled in the second round of reporting, which is quite shocking in some ways. And we also found that about 1 in 5 companies would replicate commitments from the first round directly into the second round without adapting or changing or accounting for what had happened in the intervening period. Which is why we say in the report that promises that exist only on paper ultimately do lead to broken promises. I think the final point to make is that there was a small number of companies we found that would include their commitments in first round reports and actually tick and cross and detail exactly what had happened over the intervening year period. And that is really good practice. It shows accountability, it shows a commitment to taking action and aiming to do better between reporting years, not just putting in commitments and sort of in a set and forget response and, assuming no one will be looking at what you're doing.
Thanks. Amy, do you just want to briefly tell us about sort of the most notable changes around the mandatory reporting criteria, which is set out in Section 16 of the Modern Slavery Act?
Yeah, so the good news is that between round 1 and round 2, we were seeing more companies were complying with the Section 16 mandatory reporting criteria. 2/3 of those that we assessed in round 2 failed to meet all of these, which is an improvement compared with the 3/4 that we saw in round 1. But it should be noted that we really want to be seeing 100% compliance here. So these improvements that we're detecting are coming from a low bar. So 2/3 not meeting all of the Section 16 requirements represents a high level of non-compliance with the basic reporting elements of the Act. It's interesting to note that the biggest improvement that we detected with the mandatory reporting criteria was against Section 16(1)(f), which is describing the process of consultation. There was a 17% increase in compliance between round 1 and round 2 reporting on this point. This may be connected with the fact that the government issued specialist advice on this point. That advice is available on the government's register. And it's worth noting that government guidance really does play a vital role in assisting companies to comply with the Modern Slavery Act. So one of the things that we'd be keen to see coming out of the statutory review that's currently underway is a refresh and an updating of the accompanying guidance for reporting entities, because it really does play a very crucial role. And just finally to note on the mandatory criteria, the weakest area of reporting remained describing how the effectiveness of actions is assessed by companies. This had a 61% compliance rate in round 2 and a 53% compliance rate in round 1. So the Act would clearly benefit from some further clarity around this provision in particular.
We'll open it up to more general questions in a moment. We've got about 3 slides left. Let's just focus a little bit on risk assessment, Freya, and what notable changes there were in both disclosure and evidence of action in relation to sector-specific risks of the companies that we focused on. And to answer one of the questions in the chat, as we said at the start, we were just focusing on the companies from these 4 high-risk sectors. We weren't assessing the Commonwealth Government statement.
So I think this time around, we're expecting that risk disclosure would be quite significantly improved, I think, in the second round, partly as a result of the early research early in the year, and also because there just continues to be a lot of significant media attention on the fact that the sectors that were featured in our report are high risk and are known for modern slavery instances. But I think how it's played out is that hasn't necessarily translated in the second round, and we found that 43% of companies are still failing to identify those obvious risks, although there was an improvement of about 9% overall. But in particular, we found that 72% of the fashion brands sourcing from China are still not mentioning the risk of Uyghur forced labour in their supply chain, which is really concerning. And a few of us here were fortunate enough to hear from some forced labour Xinjiang camp survivors directly earlier in the week who are visiting Australia with the World Uyghur Congress at the moment. And their harrowing stories really emphasise the dehumanising, degrading, coercive, controlling nature of modern slavery practices, and why it is so urgent for businesses to act and to ensure that they're not linked to these horrific human rights abuses. And that isn't what we have seen in our review of second round statements. So to move to the next slide, on effective action, as we've mentioned, there's been little to no change on many of the indicators that we specifically analysed. But what in the current slide actually isn't featured in our report, but it gives just a visual of the mitigation measures that we'd identified in paper promises specific to each sector, and the difference between round 1 reporting on the left-hand column and round 2 reporting on the right-hand column, where you can see there's only really a couple of indicators where there has been improvement, but more or less there is a reasonably bleak picture, I think, in terms of sector-specific measures that really could make a difference for people on the ground.
And obviously what makes this more startling is that our deliberate choice to focus on high-risk sectors, so that these are not sectors where people have to dig in and wonder, might there be modern slavery? There's a fair bit of research and documentation, media, etc., on these particular 4 sectors. So that's why we thought it would be interesting to look at this, because companies would have a level of awareness to act. And so we were looking at, how they responded around the risk of this particular. So our final point of discussion before we go to questions is to look at the recommendations in our report. Freya, do you just want to talk us through these 4 recommendations?
Sure. So at its heart, the Modern Slavery Act should be about protecting the people that make the clothes we wear, that pick the fruit we eat, that ends up on the supermarket shelves. And it's meant to ensure that businesses aren't linked to the exploitation of people in their supply chain. But right now we can see that there are serious limitations with what the Act's been able to achieve, and that reporting alone isn't going to be enough to deliver the transformative change that's needed to really seriously tackle modern slavery in supply chains. So firstly, in our report, we've highlighted that the Act needs to require companies to take action on modern slavery, not just to report, and that this needs to start with incorporating due diligence requirements into the Act. And we've recommended that that an overarching duty to prevent modern slavery be introduced into the Act itself, where the duty would be satisfied where a company can demonstrate that they've taken reasonable steps to prevent actual modern slavery from occurring in their operations or supply chains. And the Human Rights Law Centre recently published model amendments showing how this could be incorporated into the Act in practice, and I can pop a link to that in the chat for anyone who's interested. Secondly, a mandatory reporting regime needs to be made mandatory. And so there should be penalties and hard consequences for non-compliance with the requirements. And clearly our findings show there's still significant issues with reporting under the mandatory reporting criteria, but also just submitting statements in the first place. And so this is an obvious way to strengthen the Act. Thirdly, there needs to be better oversight and enforcement of the Act, including through the establishment of an independent anti-slavery commissioner. And lastly, there needs to be access to justice for exploited workers, because we should all have the confidence that the people aren't being abused when they're making the things on which we all rely. So those are the recommendations that we've highlighted in Broken Promises, which build upon the recommendations both to government and to business that are set out more fully in the Paper Promises report.
Thanks, Freya. And in terms of our next steps on this particular research project, alongside this assessment of statement compliance of year 1 and year 2, we are also conducting further research via survey. And we sent the survey to a large number of companies, not just this sort of 102 companies that we are focused on of high-risk sectors, where we were trying to dig down a little bit more to understand what was going on behind the scenes. And now, and continuing early next year, we're also conducting small, really specialized focus groups, particularly with industry, but also with some civil society, looking at, in particular at issues around remediation and reform. So what we're trying to get at by the survey and focus groups is to dig behind the statements, to try and understand what companies are doing, not just what they say they're doing, because this assessment was based on a paper assessment of the statements. We weren't going, digging down into a supply chain to see, to check these things out. So the survey and the focus group, which we're conducting now to next year, and we'll have another report coming out in the first quarter of next year, which will give those results of these surveys and focus groups, and we'll look at particularly distinctions between what you might get from a paper assessment versus a deeper dive into these sectors and the effectiveness of the Modern Slavery Act. So this particular research project will be continuing on, culminating sort of in the mid next year, but we'll have another focus of a report that will develop that. So that's the end of our presentation, but I want to go to some of the questions that we've asked. And both Serena and Robin have asked questions around risk and risk identification. And Robin says, why do you think that reporting entities aren't communicating real cases of modern slavery? Is it that they're not discovering them, or are they keeping quiet about them, or both? Amy, do you want to tackle that one?
That's a really good question. And I think that it's a combination of both factors. So in hand with the really low number of companies that we're seeing disclosing actual cases of modern slavery, there are also underwhelming results in relation to the conduct of human rights due diligence and the quality of the disclosures that we're seeing on due diligence procedures within companies. So part of it is most definitely the fact that companies may not understand how to be doing due diligence, or they may not have developed sufficiently comprehensive procedures to really be doing it effectively. There is also a reticence to disclose risks once they have been found. We would stress that this is really fundamental to having a transparency regime in place, once a case has reached a stage where it can be publicly and safely disclosed, we would very much urge companies to do this, because having that type of information available, having that honesty, having information which can be shared by those that have dealt with situations or may have a more progressive human rights approach, having that information shared more widely is a fundamental sort of foundation of the type of law that we have here in Australia. So it would be good to be fully utilising that.
And I think what we're also seeing here, and part of our report, is that essentially what we have is largely an underregulated or not regulated law here by the public sector. And so that's part of our recommendation, is that if we're going to put these laws and practices in place, then we need a well-resourced regulator that is going to follow through and be able to dig down, not just into non-compliance or non-submission of reporting, but also starting to look at the quality of that reporting. Because what we want to change are business practices. We don't just want to get to a state where reporting is fantastic. What we want to see is that the reporting then builds on changes in practices, and that companies are starting to identify risk and acting on them. What we would like to get to is a situation where identification of modern slavery risks are normalized, that companies are actually seen around that as leaders, and there's sufficient information provided in risk identification that you can actually see what occurred. Because some of the reports that we looked at where you might say risk was identified, it was so vague, it was really hard to tell where it happened, what happened, and what was going on, and what was the response, even in these high-risk sectors. One exception, I think, was a report that came out after this reporting period, but this year by Woolworths, where they've, in their most recent report, have given really clear details about incidents of modern slavery they found in a supply chain, and then what they've done to address that. And that's the situation I think we want to get to, where it's more normalized. So while much of this is, bad news, there's also some good news that we found. There's a question from Vanessa Freya around, can you share any general examples of where there might be good practice around this? Or perhaps also, if we don't have those good practices, what would we need in terms of amending the law to make sure that we do have more good practices to offer next year or another time?
Yeah, thanks, Justine. And just quickly on the last question, in paper promises, we definitely found a correlation between the 8% of companies that reported incidents or allegations of modern slavery and the detail around their human rights due diligence that was included in statements, which was kind of an interesting linkage. But in terms of good practice, in paper promises, there's quite a few different examples from company statements directly that demonstrate stronger practice, better disclosures. There's one around Xinjiang in there that I think might be from Kathmandu. But I think the government also has a role to play in giving more guidance around what good practice looks like. As Amy mentioned, I think that the past reporting guidance to entities that came out when the Modern Slavery Act was sort of just in its infancy was really good at the time, but there's now room for improvement with the experience that we've had over the last couple of years. And there's probably a really good piece of research to do in that to identify the ways in which companies can strengthen their disclosures, but also their underlying actions.
And I think that my example I just gave then is also one of those of good practice, where we're starting to normalise practices and reporting practices around this. One of the questions also raised is around human rights due diligence and what that looks like and how we might frame it. Freya, I know you've thought about this particularly in legal terms, and there might be some examples from Australia, including the most recent Respect at Work Act, that might give us some clue about how we frame this so-called duty to prevent modern slavery and what that might look like.
Thanks, and I'm just putting a link in the chat to the draft legislation that we've published recently. But I think that the new Respect at Work Act provides a really good example of a framework that is outcomes focused, because I think the last thing that anyone working on modern slavery issues wants to see is a sort of tick box compliance-driven approach to addressing modern slavery risk. Modern slavery is difficult to detect. It is about risks to people, not risks to the business. It needs to be done in a sensitive, rights-informed way. And so including a duty that directs company efforts in the direction of really drilling down into what are the key risks for the company in terms of prioritizing risks, where do you put resources to have the biggest impact on the people that are likely to be affected by your company's sourcing practices or your own operations, is what we would like to see the Act reoriented into. At the moment, we've seen that the mandatory criteria are directing efforts towards certain key aspects that could form part of a human rights due diligence process, but there needs to be greater guidance to require companies to actually take those steps to identify, mitigate, act on and remediate where appropriate modern slavery instances. And where there's a failure to take reasonable steps, companies should be held accountable for a failure that results in actual modern slavery occurring.
And I would
Amy, sorry, go ahead.
I would just add to what Freya's just said, that one of the elements that we at the Resource Centre see as being really fundamental as well is having effective engagement with those that are, affected or potentially affected by the activities of your company. So having that sort of, baked into any due diligence approach. So thinking about how effective and safe stakeholder consultations can be incorporated into due diligence activities is really key.
Yeah, and stakeholder engagement is one of those terms I think gets thrown around a lot, like human rights due diligence is starting to as well. And what I think companies need to think about is, how do you actually do this in a meaningful way? How do you get, if it's not direct access to workers, it's their representative, it's working with civil society and experts around that. But it's going outside sort of as a safe zone of internal corporate operations and the people that you have doing audits, etc. But to actually look outside and look at people who are out in the field doing this work, or who are in contact with those. But stakeholder engagement also has to be something that's not one-off. It's got to be an ongoing process, like human rights due diligence is. And conducting a social audit isn't a proxy for human rights due diligence. Human rights due diligence is this ongoing sort of process of consultation, and then showing how you are mapping practices and changing business practices in response. We're almost out of time, but Amy, there were a couple of questions about the review process. Can you just remind people what is happening with the government review and when we're likely to hear responses on that?
Yeah, so the review process is spanning a year and will conclude at the end of March next year. There's been a period for written submissions, which has recently closed. And Professor John McMillan, who's running the review, has gone out very widely. He's been consulting with all stakeholder groups and will be holding further targeted conversations following the conclusion of the written submission period. And then next March or shortly after, we can anticipate the report being issued by Professor John McMillan with recommendations on next steps for the Modern Slavery Act.
Thanks, and we are out of time, and so thank you for all joining us today. I really encourage you to read the report, because most of the questions you've asked that we have not got access to, the answers are in the report. And if you also have questions around the government aspects, you can look on the website. The Modern Slavery Business Engagement Unit is now part of the Attorney General's Department. They've got a website, and they can also have got a contact point in relation to that. As you can see, this report has taken literally hundreds, thousands of hours. We've been working on these reports over 2 years now with 5 universities and 3 NGOs. And so it's an amazing collaborative research investigative team that much of this work has been done largely unfunded, sometimes supported. One of the questions was, are we going to continue? Yes, if you'll give us some money to do it. But we will continue all working in this area, and also the survey and focus groups report. We look forward to connecting with you next year on this. Thanks for joining us today. Thank you, Freya and Amy, and have a good day.
Thanks.
Thanks, everyone.